Prince Harry, the Duke of Sussex, took his place in the witness box, a position starkly removed from the ceremonial comfort of Buckingham Palace, as he endured an exacting cross-examination in his legal action against Associated Newspapers Limited, known as A&L. The case represents more than a personal grievance. It is a complex legal confrontation rooted in allegations of unlawful information gathering, phone hacking, and the tabloid industry's long-standing pursuit of sensational headlines. At its core, this lawsuit once again exposes the deeply strained relationship between the British royal family and the press. The Duke's testimony, carefully examined by legal professionals and followed closely by the public, has offered an unusually candid window into the internal mechanics of the monarchy, the realities of constant surveillance, and the personal cost of relentless media intrusion on both individuals and their families. This is not a solitary claim. It is a coordinated legal action, with Prince Harry aligned alongside high-profile figures including Sir Elton John, Baroness Doreen Lawrence, and actresses Sadie Frost and Liz Hurley. Their shared complaint centers on what they allege was the systematic and unlawful conduct of A&L journalists in obtaining private information. According to the claimants, these practices included phone hacking, the illegal interception of voicemail messages and personal data, as well as blagging, a deceptive technique involving impersonation or fabrication to extract confidential material. They further allege the use of additional illicit surveillance methods. The argument is straightforward, that A&L's pursuit of exclusives came at the expense of basic privacy rights, crossing legal and ethical boundaries in the process. A central focus of the cross-examination was A&L's attempt to weaken Prince Harry's credibility. The defense suggested that the Duke had used the pseudonym Mr. Mischief to communicate with Charlotte Griffiths, a diary editor at the Mail on Sunday. A&L's legal team presented what they claimed was evidence of a Facebook connection between an account bearing that name and Griffiths, alleging friendly exchanges and the sharing of Prince Harry's personal mobile number. The implication was unmistakable. A prince who has positioned himself as a critic of tabloid excess was, according to this narrative, privately engaging with a tabloid journalist, potentially providing information or, at the very least, participating in interactions that would sit uneasily with his public stance against press intrusion. Prince Harry rejected these allegations outright. He denied ever using the pseudonym in question and insisted that his contact with Griffiths was limited and insignificant. He recalled encountering her at a social gathering hosted by a mutual acquaintance, Arthur Landon, but stated that he discontinued any interaction once he became aware of her role as a journalist. He also challenged claims that he had socialized with her in Ibiza, stating clearly that he had visited the island only once, accompanied by his wife, Meghan Markle, and their son. This denial carries considerable weight. Had Prince Harry been shown to have covertly communicated with a tabloid journalist, it would have dealt a serious blow to his credibility and to his claim of being a victim of press misconduct. It would inevitably prompt questions about his motivations for pursuing legal action and undermine assertions that he sought to distance himself entirely from tabloid media. The cross-examination, conducted by Anthony White KC on behalf of A&L, was marked by sharp exchanges and sustained pressure. White's approach was to challenge the Duke's account, probe for inconsistencies, and draw attention to his historical interactions with journalists. He questioned Prince Harry's understanding of media practices, his failure to formally object to articles at the time of publication, and his interpretation of the royal doctrine of never complain, never explain. Prince Harry responded by defending his conduct and accusing A&L of orchestrating a deliberate campaign to damage his reputation and violate his privacy. He argued that the long-standing policy of silence had prevented him from responding earlier, but that he had now reached a point where legal action was unavoidable. He also spoke at length about the toll of media intrusion on his wife, Meghan Markle, stating that it had made her life profoundly difficult and contributed to her struggles with mental health. His testimony offered a rare and personal account of life under sustained public scrutiny. He described the strain of existing in an environment where privacy is effectively unattainable, where personal communications risk exposure, and where surveillance feels constant. He was openly critical of the never complain, never explain approach, arguing that it had allowed unethical practices to flourish unchecked. According to the Duke, the policy may have been designed to shield the monarchy from criticism, but in practice it enabled the press to shape narratives with little resistance. This case, he insisted, extends beyond his own experience. It raises fundamental questions about press ethics, accountability, and the limits of lawful journalism. The claimants are seeking not only redress, but a legal precedent, one that would discourage media organizations from resorting to illegal or unethical means in pursuit of stories, and reaffirm the principle that the public interest does not justify unlawful conduct. A&L, for its part, has categorically rejected all allegations and has stated that it will robustly defend itself against the claim. The publisher maintains that its journalists acted both lawfully and ethically, and that the material published was gathered in the public interest. It further argues that the claimants are seeking to suppress legitimate journalistic scrutiny and to silence critical reporting of their conduct. A&L insists its reporters operated squarely within the law and that all published information was obtained through standard and lawful journalistic methods. The company contends that the claimants are attempting to weaponize the courts to censor the press and restrict the publication of stories that portray them unfavorably. The trial, expected to run for several weeks, is already attracting intense attention. Its outcome could carry far-reaching consequences for press regulation in the United Kingdom and for the long-standing, uneasy relationship between the media and the royal family. Beyond that, the case may influence privacy law and journalistic standards well beyond Britain's borders. During his evidence, Prince Harry addressed specific articles he believes were sourced through unlawful practices. He pointed to what he described as factual inaccuracies and distortions, arguing that they demonstrated a willingness within sections of the press to bend the truth in pursuit of sales. He maintained that certain details published could only have been obtained through phone hacking or other illegal techniques. He spoke in detail about the emotional strain these articles caused, not only to himself but also to those around him, including close friends and family members. A particularly sensitive issue concerned media coverage of his relationship with his former girlfriend, Chelsea Davy. Prince Harry argued that she was subjected to sustained scrutiny and harassment by the press, pressure which he believes ultimately played a role in the relationship's collapse. He further claimed that private information relating to Ms. Davy had been obtained through unlawful means, including alleged phone hacking and the interception of personal correspondence. He described the severe impact this intrusion had on her life, and the personal guilt he carried for exposing her to such scrutiny. The Duke's testimony also touched on internal royal dynamics and the difficulties of managing media exposure. He revealed that his grandmother, Queen Elizabeth II, maintained a firm rule that girlfriends were not invited to spend Christmas with the royal family. He also acknowledged that he did not closely follow the Leveson inquiry into press ethics and rejected the idea that members of the royal family are in constant communication. He said he was unaware of who within his family may have brought legal claims against tabloid newspapers. These disclosures offered an uncommon insight into the inner workings of the monarchy and the complexities of its personal relationships. When questioned about his awareness of the campaign group Hacked Off, Prince Harry said he had only become familiar with the organization within the past 4 or 5 years, adding that he believed they carried out fantastic work. That comment reinforced his support for groups campaigning for media reform and accountability. It reflected his broader commitment to strengthening privacy protections and raising ethical standards within journalism. Throughout his evidence, Prince Harry remained outwardly composed, though frustration and anger were evident beneath the surface. He spoke forcefully about the need for reform and the importance of safeguarding individual privacy from intrusive reporting. He reiterated his determination to hold A&L accountable for what he alleges were unlawful information-gathering practices. His conviction was unmistakable, and he made clear he had no intention of retreating. The presiding judge, Mr. Justice Nicklin, intervened on several occasions, reminding the Duke to answer questions directly rather than respond to allegations. He stressed that legal argument was the responsibility of counsel and that Prince Harry was not required to defend himself personally. These interventions were intended to ensure the proceedings remained fair, efficient, and focused. Despite this guidance, Prince Harry continued to elaborate on his answers, explaining that he wanted the court to understand what life is like under constant surveillance. He told the judge he wished to convey the reality of living in a world of continuous observation. That statement captured the intensity of the pressure faced by Prince Harry and his family. It underscored the cumulative toll of sustained media attention. The trial is expected to continue for several more weeks, and its ultimate outcome remains uncertain. What is already clear, however, is that Prince Harry's testimony has cast renewed light on the complex and often adversarial relationship between the monarchy and the press. The case has reignited debate around privacy, press freedom, and media responsibility, with potential implications for future regulation in the United Kingdom. Following his court appearance, Prince Harry issued a statement reaffirming his resolve to hold A&L accountable. He said he believed the evidence would demonstrate a systematic effort to invade his privacy and damage his reputation. He pledged to continue his legal fight. A&L responded through a spokesperson, stating that it is for the judge alone to assess the evidence of a witness, not for Prince Harry or his representatives. The spokesperson added that statements perceived as naive or self-serving during an ongoing trial were inappropriate. A&L has continued to assert that its journalists acted both lawfully and ethically, maintaining that the lawsuit represents an effort to suppress legitimate press scrutiny. The legal confrontation between Prince Harry and ANL is emblematic of a broader and growing tension between the media and individuals who believe their privacy has been breached. In recent years, awareness of the damaging consequences of media intrusion has increased, prompting more individuals to pursue legal remedies to defend their private lives. This case has come to symbolize the wider struggle for privacy rights in the digital era. The outcome of Prince Harry's claim could carry serious consequences for the future of privacy law in the United Kingdom. A ruling in his favor could encourage others to pursue legal action against media organizations accused of violating privacy. It could also pave the way for tighter press regulation and increased accountability across the industry. Such a verdict would establish a precedent reinforcing privacy protections and restricting the scope of intrusive reporting. Conversely, a ruling in favor of ANL would signal that the press retains wide latitude to engage in aggressive reporting without significant legal consequence. That outcome could discourage individuals from challenging media power and deter those who feel wronged from speaking out. A victory for ANL may weaken existing privacy safeguards and embolden news organizations to continue intrusive practices with renewed confidence. The case is being monitored closely by media groups, legal analysts, and privacy advocates worldwide. It is widely regarded as a landmark dispute with the potential to reshape the balance between press freedom and individual privacy. The decision will influence legal standards and define how those competing rights are weighed. For years ahead, Prince Harry's determination to confront entrenched tabloid practices is rooted in a conviction that the pursuit of sensationalism should not override personal dignity or well-being. He has seen firsthand the harm that intrusive coverage can inflict on individuals and families, and he has chosen to use his position to push for stronger accountability and higher ethical standards within the press. His experiences have intensified his resolve to drive meaningful reform. This lawsuit, he insists, is not driven by personal animosity. It is, in his view, a principled challenge to a systemic failure within the British media. He argues that unchecked tabloid power has fostered an atmosphere of intimidation, where individuals hesitate to confront journalists for fear of further exposure and harassment. Prince Harry regards this case as an opportunity to disrupt that imbalance and restore a measure of fairness. By taking on ANL, he aims to dismantle what he sees as a culture of impunity and encourage others to assert their rights. His message to the media is direct: power does not confer immunity, and accountability is unavoidable. The dispute also underscores the evolving relationship between the royal family and the press. For generations, the monarchy relied on media coverage to shape its public image and sustain popular support. In recent years, however, that relationship has deteriorated as reporting has grown more aggressive and invasive. The rise of digital platforms and social media has only intensified these pressures. Prince Harry's legal action signals a clear refusal to accept what he views as media excess. He is intent on protecting his own privacy and that of his family, even if doing so challenges long-standing conventions of royal media relations. In doing so, he is charting a new course for how the monarchy may engage with the press. The outcome of the case will carry significant implications for that relationship. A victory for Prince Harry could prompt other royals to pursue legal redress over privacy breaches, potentially ushering in a more confrontational dynamic between palace and press. It could also mark a shift in the balance of power. A defeat, however, would suggest that the royal family remains largely unable to curb media intrusion. That outcome could encourage even more invasive reporting and reinforce perceptions that the press operates beyond meaningful restraint. This case represents a high-stakes gamble for Prince Harry, but one he appears willing to take in defense of privacy and accountability. His actions have already ignited a national conversation about press ethics and the limits of journalistic freedom. Whatever the verdict, its consequences will extend far beyond the courtroom, shaping the ongoing debate over the public's right to know and the individual's right to privacy.